Well, unlike trying a case to conclusion before the courts or arbitrating a case before an arbitrator, mediation involves a neutral not making a decision, but helping the parties, facilitating the parties' discussion to a dispute and ultimately getting them, hopefully, to agree to a resolution. So that's the big difference, and it's not only a very cost-effective, from a monetary point of view, resolution, but it's also one that can avoid all the tremendous cost and anguish of actually trying a case to conclusion.
Are there times when clients, attorneys don't want to look at the mediation option where the client needs to be more informed to sort of help direct their lawyer in that direction?
Over the 40-some-odd years that I've been trying cases, because I'm a trial lawyer, I can tell you that there are lots of times when there are roadblocks to trying to get an early resolution through mediation or otherwise, either because of the clients and they're not ready or willing to consider a resolution, or sometimes from time to time counsel also prove to not be very helpful in that regard.
Right, so it's a complicated road at best.
Well, when you get into the nature of disputes that ultimately come to the filing, for instance, of a lawsuit, you know, at that point the piece is pretty much ginned up pretty high insofar as emotions are concerned.
You know, I'm thinking that a lot of mediation isn't binding, correct? There's binding and there's non-binding mediation?
Well, most of the mediations that you go into are binding. Mediation is something that you do by consent. It is not something that is ordered, certainly in this jurisdiction, unless there's an agreement, a pre-existing agreement, to mediate by contract. But unlike states like Michigan, for instance, where mediations are mandatory, in Massachusetts that's not the case unless there, as I say, there's an agreement to mediate.
Is there a logic for both